Good morning, ladies and gentlemen. Our first case for argument is SELAC against the Nicolet Union High School District. Mr. Giordano.
Good morning, Your Honor, and may it please the court. My name is Philip Giordano, and I'm the attorney for the plaintiffs and the appellants, Joel SELAC and Baron Hodges in this case. We are here regarding the decision of the District Court for the Eastern District of Wisconsin regarding a claim that had been brought under Section 1983. Without going too detailed, in July of 2022, Mr. SELAC and Hodges filed their complaint in the Federal District Court alleging 4 causes of action: violations of substantive due process, denial of equal protection, 1983 for failure to supervise, and a claim under Section 1985. As this court, I'm sure, is well aware of the circumstances, the claims that have been brought are under the Monell line of cases, and Mr. SELAC and Mr. Hodges were students of the defendant, Nicolet High School. In the 1980s, Mr. SELAC and Mr. Hodges were students that were sexually abused by a teacher, David Johnson. They were repeatedly abused, and they were abused off campus at Mr. Johnson's apartment and on off hours. The claims that have been brought by the plaintiffs deal with the various elements under Monell liability, which establish municipal liability, and the plaintiffs have the duty to demonstrate an underlying constitutional deprivation, municipal action that amounts to a custom, policy, or practice, deliberate indifference by the municipality to the plaintiff's constitutional rights, and the municipality's action was being the moving force behind the plaintiff's injury. The complaint was filed, and the U.S. District Court had considered a motion to dismiss by the defendants, and there was briefing that was done, as I'm sure this court is aware. No oral argument was allowed, and the plaintiffs had asked if deficiencies were identified for leave to amend, all of which were denied. There was no opportunity for my clients to have even an opportunity to redress or hear or to present argument regarding the deprivation of constitutional rights that they suffered. The court found that there was no legally sufficient case that could be brought under the Monell liability. Now, as this court is well aware, there was an investigation that had been done, and that demonstrated that in 1983, Baron Hodges had complained to a particular Nicolet teacher and told her of the circumstances of the abuse that was going on by David Johnson. The Nicolet teacher did the right thing. She went to her supervisor and made a report through her husband to the Glendale police. Mr. Hodges was a freshman at the time. He was one of the few minority students in the Nicolet school. And in July of 1983, the school board held a meeting to which Mr. Johnson attended. And they were on actual notice as to the circumstances of what was going on with David Johnson.
So, Mr. Giordano, on appeal then, you are not arguing that Mr. SELAC's report of the incident to Mr. Rice in 1980 constituted notice to the school board, is that correct?
No, we still maintain that I was going to address Mr. SELAC separately, but we are still maintaining, as according to our brief, the 1980 report to Mr. Rice was notice that was given to Nicolet. And the substantiation of that, because recognizing that Mr. Rice was not at the apex of authority, he was not the Nicolet board. However, it is clear, not only from the allegations, but from the very words of the defendants themselves upon their investigation, that the Baron Hodges circumstance was not the only circumstance to which the 1983 board meeting was considering. They considered it for multiple students. So we suggest that especially at the motion to dismiss stage, that the Nicolay board and the policymaking authority had that actual notice that arose presumably out of the Rice communication.
But what allegations can you point to that would substantiate the claim that there were numerous other reports of similar conduct to the school board in 1980?
Well, we don't, I believe, put the word numerous in our pleadings. However, I would direct this court's attention to the actual investigation that was done by the investigator interviewing members of the board, which is Exhibit Z to our pleadings. And
But my understanding is that that deals with what the board knew or didn't know as of 1983. What about with regard to 1980?
Well, the board determination in 1983 discusses students. And in paragraph 5 of Exhibit Z, which is the findings signed by the investigator after interviewing the board members, specifically says, the board discussed Mr. Johnson's inappropriate invitation to students to perform physical exercises at Mr. Johnson's home. Now, purportedly, according to the Nicolay defense, only Baron Hodges is the one that has come to their attention. And we are at the motion to dismiss stage. We are obviously not any discovery. They have control of all the information. And that allegation, which is incorporated by reference, it must be given high credibility because it is a statement of the investigator of the board members of the 1983 meeting.
So from that, you would like us to draw the inference that you believe is reasonable that back in 1980, there were sufficient instances that were reported to the board that the board knew of it as of then?
What I'm saying is that together with the allegation of Myra Taxman, when she communicates directly with the teacher.
Again, that's 1983, right?
That's still 1983, but it is talking about predating the July 1983 event. And I think the inference, together with what is clearly the deliberate indifference that was demonstrated by the Nicolay board.
How so? Where were they deliberately indifferent? You're talking about a meeting, an investigation. Where were they deliberately indifferent? Burying their head in the sand and not doing anything?
I know of no investigation that was done. I don't know, perhaps Nicolay has that information. We do not, nor have we alleged it. There is an interview.
But didn't they take action against Mr. Johnson?
Well,
and didn't they write a report?
Well, we don't know of a report. The report was done in the 2017-2018
got it. But they took action against Johnson. You said they had a meeting and they took action against Johnson, right? They reprimanded him or whatever it was that they did back in 1983.
But what they did is they said, Mr. Johnson, we're going to give you one bite of the apple on sexual abuse.
But how is that deliberately indifferent? Deliberately indifferent equals doing nothing.
And it does. Because in this circumstance,
I don't understand the contention that doing nothing and doing not enough in the plaintiff's view are identical.
But doing
What
nothing.
is it that establishes the proposition that action that doesn't satisfy the plaintiff is the same as no action?
No, I think the comparison should be made as to the doings.
Don't just say no.
I apologize, Your Honor.
Question. You need to answer the question.
I apologize, Your Honor, respectfully. I apologize. I think the standard that should be compared is the 2017-18 actions when they were notified of this.
You're not answering my question.
I apologize. Could you restate
What
the question?
authority do you have for the proposition that doing nothing should be equated to not doing enough?
For the purpose of deliberate indifference, is that the question, Your Honor? Because
You can cite whatever authority you have.
the deliberate indifference that we are referencing.
Look, I have asked a precise question. What authority do you have for the proposition that doing nothing should be equated to not doing enough? Now, there may or may not be any authority for that, but I wish you would address that question.
The Laporta case talks about deliberate indifference. And we suggest that doing something, particularly where it is not on campus.
So
when
do you think the Laporta case supports the proposition that not doing enough is the very same thing in the eyes of the law as doing nothing?
It's not the very same thing, Your Honor.
No, it isn't.
Agreed.
But you've been equating them, and you need to face up to the fact that they are different.
I fully understand that. But deliberate indifference does not always just equal nothing. What it also references, which is the circumstances of this case, is putting into place
If you look at the Eighth Amendment cases,
I apologize.
if you look at the Eighth Amendment cases where deliberate indifference is very important, that's actually a fundamental difference. If the prison's doctors intervene, but poorly and ineffectually, they don't violate the deliberate indifference standard under the Eighth Amendment. That's very well established. You're arguing that this should be treated differently, and I'm trying to figure out whether you have authority for that, and if so, why. It is the same deliberate indifference standard.
I am not familiar with Eighth Amendment cases, so respectfully I can't say whether that is applicable to this particular case. But I do believe that it is clear from the Laporta and from the case law that deliberate indifference cannot mean that they can abandon the children that are subject to their responsibility. So that's where you get in a comparable circumstance as White versus Rucker, where the police left the children on the side of the road and they were abandoned. And that is analogous to the circumstances in this case, because the abandonment of the students, including the plaintiffs, Mr. Hodges, who had made the reference to the teacher, which was brought to the school board, and the only steps that they took were ones to monitor him allegedly on campus, where there were no allegations of abuse being occurred. They were off campus and off hours. They certainly did not try to put in any notification to the Nicolay community. They did not notify the police. They did not terminate Mr. Johnson.
What rule of federal law requires the police to be notified?
Well, not of federal law, but many states, and we are now talking
No,
the duty.
your claim is one under federal law.
Understood.
So I have a simple question. What rule of federal law requires the police to be notified?
I'm not aware of one.
You are aware that the Supreme Court has expressly rejected such arguments.
I am that
Most recently in United States against Texas.
understood.
Well, if you pitch your case on a theory that the Supreme Court has rejected, you can see why you're getting skeptical questions. You
Understood.
need to pitch your case on a theory the Supreme Court has accepted.
The facts of whether or not the actions are subject to whether or not it's deliberate indifference should go to a fact finder, not just on a 12b6 motion. I think that this court's position and the skeptical views that you are now expressing may result in a motion for summary judgment or may result in a jury verdict against the plaintiffs. But we never even got to that stage. We never were even granted leave to amend, but the most appropriate determination, which many of the cases have, is after discovery has occurred, where a fact finder
There's
is...
one other issue you need to address. The defendants contend that we should affirm the judgment on an alternative ground, that is, that the suit is untimely. You've been mentioning events from the 1980s. The Wisconsin statute of limitations applicable at the time was 6 years, or 2 years from reaching the age of majority. It does seem that this case is rather late.
Agreed. The notification occurring in 2017 to 2018, when the Nicolay Board conducted its investigation. And this court has upheld in Barry Aviation the discovery rule, and particularly in light of circumstances where
What you
there's
need to discover is your injury. But there seems no doubt that Seeback and Hodges discovered their injury, well, more than 40 years before this suit was brought.
I would
Isn't
refer
that
to
a problem?
I would refer this court to Snyder Hill versus Ohio State, where the court specifically said, and that's a Sixth Circuit case recognized, says that a body of literature specifically says that people do not recognize that they have been sexually abused. They have not.
Has the Supreme Court ever adopted that rule?
I'm not aware
The
of
Supreme Court's rule for accrual of a claim under federal law is the rule stated in United States against Kubrick, which is you have to understand you've been injured and by whom.
Again, the discovery rule, which this
No,
court.
I'm asking a question about a concrete Supreme Court case. I'm inviting you to discuss the rule in Kubrick and explain, if you can, why that rule is not dispositive.
I don't think I'm only somewhat familiar with the rule with the determination in Kubrick, but to me, Your Honor, and I think one must consider the stage of the case and the fact that nothing has occurred except a complaint, not even an amended complaint. That would leave opportunities for further.
I don't think I'm getting through.
I'm sorry
I'm
about that.
inviting you to discuss the rules of law that govern this issue. Right?
And
This is your opportunity to discuss the rules of law.
completely understand.
Your reply brief responds by saying, well, it took extensive therapy for the plaintiffs to get up the courage to file such a lawsuit. That does not seem to be consistent with the legal standard in Kubrick. That's why I'm giving you a chance to discuss the legal standard, which your reply brief didn't do. I'm trying to do you a favor, counsel.
And I understood it, and I appreciate that, Your Honor. The reply brief specifically refers to the fact that the accrual of the date cannot be determined until the injury is discovered or should have been discovered. And therapy and therapeutic sessions, being a very inexact science, do not specifically determine, particularly where you have a young child who's a freshman in high school, does not know, even if he reaches the age of majority, that a statute of limitations would occur and that
Look, the Supreme Court has held that not knowing about the statute of limitations is not relevant. The
understood.
Supreme Court has held that not knowing that the behavior was actionable is not relevant. That was the precise holding of Kubrick. You don't need to know that you have a legal claim for the time to be running. You really need to phrase your argument in terms of the Supreme Court standards.
But the discovery rule goes to when the injury.
This has nothing to do. I give up.
Well, Your Honor, I would respectfully ask if I can reserve the remaining time for rebuttal.
Certainly, counsel.
Thank you.
Mr. Tomei.
Good morning, Your Honors. May it please the Court. Attorney Matthew Tome on behalf of the defendant Appellees. I guess I'd like to begin first, with Judge Lee, your earlier question relating to whether or not the plaintiffs are arguing on appeal that, in fact, the 1980 notice should lead to any liability for the defendant Appellees, the notice to the gym teacher. I was surprised to hear that they are now arguing that on appeal, and I think it presents some of the problems we have faced in this case, which are outlined in our waiver argument, which is that there seem to be very shifting sands in terms of the theories and the arguments that the plaintiffs are making. I won't belabor the waiver point. I mean, it's addressed in the briefs, but I'll make two brief points. One, the arguments that the plaintiffs are making on appeal are not nuances on the claims they presented below. As I understand their arguments on appeal, they are now arguing.
There's only one claim in this case. There are just multiple legal arguments.
Understood, Judge Easterbrook. I would say the underlying constitutional violation on which they are basing their claims of Monell liability and supervisory liability is different. The underlying constitutional violation that they alleged below was the alleged sexual abuse of Joel Selak and Baron Hodges as students between 1980 and 1983. The underlying constitutional violation on which they are relying on appeal was the alleged sexual abuse of Joel Selak as an adult, well after he had graduated in the post-1983 period, and what they claim is the psychological harm that Baron Hodges incurred by being in school after 1983, even though he was no longer being sexually abused. Those are distinct underlying constitutional claims on which they're basing their Monell, underlying constitutional theories on which they're basing their Monell liability. And I think for that reason, we don't think it's a nuanced argument. We think it's a new argument on appeal that was waived below. I mean, certainly with respect to Selak, the district court expressly found waiver. I mean, it's in the district court's opinion, notwithstanding the arguments that are now being made. It was expressly found waived. I guess the last point I'll make is obviously the court has discretion to address new arguments. That's something you do. I think it's rarely granted. I think this is a case that probably doesn't call for it. To quote Alioto, this appeal does not warrant an act of grace. The plaintiffs were represented by counsel below. They didn't make those arguments. I'm happy to address any questions the court has with respect to deliberate indifference or the plaintiff's constitutional theories, but we think this is it's a pretty straightforward case at the end of the day, and I think this is why the district court didn't grant leave to amend, because like the Boncheck case that plaintiffs' counsel brought prior to this one, the alleged acts of sexual abuse of the plaintiffs as students occurred prior to the school board ever having notice.
Do we have any insight into the school board's thinking on why it gave or imposed the restrictions that it did on Mr. Johnson versus any other restriction? So in other words, Judge Easterbrook, correctly did correctly state the standard for deliberate indifference. And the question really goes to the subjective belief of the school board, right? And certainly if there's evidence, although I don't see it, if there's evidence or allegations the school board knew that it was going to be ineffectual, right? That knew that these measures were half-hearted, knew that they would be futile, that would be one thing. If the school board honestly believed that the restrictions that it imposed would be sufficient to address the concerns, that's quite another. And I was wondering if there's anything in the record that so far as we can see that would lead one to lean one way or the other on that.
I don't know that there's anything in terms of the record, in terms of the investigation that was conducted. It's my understanding, I'm quoting the record from memory here, but that the recollection of board members was that conditions were imposed, that the letter couldn't be found, there was a flood in the district in 2010. But I think in terms of facts that are alleged in the complaint or aren't alleged in the complaint, what is not alleged in the complaint is that there was an act of sexual abuse of a student after the board meeting in 1983. Obviously,
and there's no allegations in the complaint that I could find that the board acted knowing that their restrictions would be futile or ineffectual.
No, not that I'm aware of. I think the only acts of abuse post-dating the 1983 report were with respect to Mr. Selak, who at that point was an adult. And again, this is in the briefs, but I don't know how you can say that the school board is on notice or being deliberately indifferent to the possibility that Mr. Johnson was engaging in sexual abuse with somebody who had already graduated and was an adult. So I just don't think those facts are there. At the end of the day, I think the briefs adequately address the points we want to make. I'm happy to answer any questions the court has with respect to any of our other arguments. With respect to the amendment question, I understand, generally speaking, courts give one opportunity to amend. I'll just highlight the points we made in our brief. There was never any proposed amended complaint. I know the judgment was entered at the same time the order came down. I know that doesn't always happen, but often people will make a motion after a judgment is entered at the same time the order comes down for, I believe, a Rule 59 motion, and at which point they will identify what they want to include in an amended complaint. And I think the plaintiff's appeal brief doesn't include any additional facts that they would include in an amended complaint. I think ultimately it's they're arguing their new theories based on the facts that they alleged in their original complaint, but in terms of actual new facts that they would include in a new amended complaint, I don't think they're there. And given the waiver issues we believe we've identified, I think granting them leave to amend to reassert claims that were never properly preserved before the district court in the first place, I think you've got futility issues, and I think you've got undue prejudice issues at that point. So with that, I will sit back down unless the court has any questions.
Thank you, counsel. Anything further, Mr. Giordano?
Just briefly, Your Honor. With respect to the Bonchek case, that is part of the basis of the district court's decision. Bonchek is clearly distinguishable in that he graduated before the 1983 report. He never returned to Nicolet thereafter. He had no further contact with Mr. Johnson. In sharp contrast, Mr. Hodges was a student for 3 continued years thereafter. Mr. Selak continued to have contact and was abused by Mr. Johnson for the next several years into his 20s. Clearly, the lack of the ability to amend was based upon the district court's decision that there was no legal plausibility. There was no right or character.
Did you ever tell the district judge what you would add to the complaint if allowed to amend?
I did not have anything specific, but clearly a right to amend would have been.
Because I didn't see that in your appellate brief either.
There was no oral argument which I had.
No, look, I said I didn't see that in your appellate brief either. So tell us what you would add if allowed to amend.
Mr. Hodges suffered psychological harm, as we say in paragraph 103 and 131 of the complaint.
This is something you would add if allowed to amend.
Yes.
Just putting underlining under something already there, it doesn't do it.
Additional allegations of the circumstances for the next 3 years. The multiple years that Mr. Selak continued to be together with Mr. Johnson and abused by Mr. Johnson is not fully fleshed out in terms of allegations. Those allegations are addressed in the complaint, and they would have been certainly further addressed together with the psychological harm that my clients had suffered. Those were allegations that we would have, and again, it's unheard of not to even get one opportunity to amend when a request is made, and we had made that request. Thank you for your time. Thank you, Your Honor.
Mm-hmm. Thank you very much, counsel. The case is taken under advisement. Our next case this morning is American Zurich Insurance Company against Sun Holdings. Mr. Henry.
Yes, Your Honor. Good morning. May it please the court. Let me first say it's an honor and a pleasure to be presenting argument in this court, as it's my first time in the Seventh Circuit and me and my family's first visit to Chicago, so I thank the court for this opportunity to present argument. I'd also like to preface my argument by admitting that I understand the uphill climb or the steep hill that parties face when attempting to vacate or modify an arbitration award. But in our view, based on the briefing and what happened in this case, it shouldn't be any easier to convince a court to adopt a rule that contravenes the express terms of the arbitration award. So I hope to persuade you that the district court erred in confirming the award of attorney's fees here, because this court, even if it agrees in principle with ReliStar, need not apply ReliStar in this circuit in whole or follow it to the point where this case would fall within ReliStar's ambit. In one paragraph, the district court found that the arbitration panel drew its authority to assess attorney's fees for bad faith conduct in arbitration from the case out of the Second Circuit in Relastar. That allows attorney's fees to be awarded in the face of a specific arbitration provision that basically limits the arbitrator's authority to award attorney's fees.
So, Mr. Henry, going to your point about the uphill climb here, it doesn't really matter, does it, whether we here agree with the holding in Relastar or don't agree with the holding in Relastar, so long as the arbitrators considered it and had some basis in their arbitration agreement to consider it.
Well,
Isn't that correct?
that would fly in the face of this circuit's opinions in Tootsie Roll, the Bush, U.S. Soccer, that basically say that an arbitrator's authority is limited by the contract, and basically over many cases in which courts across the country, but this...
No, I don't think you got the gist of the question.
Yes.
The arbitrator is limited to interpreting the contract, but that doesn't mean interpreting it correctly. Arbitrators here certainly purported to interpret the contract. You've said that you don't agree with their interpretation, but we've said that's not a ground for upsetting an arbitrator's award. I mean, what's left?
That's correct. There's cases where the word cost is used, and this court has held that if the word cost is used and that could be held to be ambiguous, the arbitrator can interpret the contract. Likewise, there's cases where there's silence on fees. This court and other courts have held that's within the arbitrator's hand. What this court has held is that...
Counsel, the arbitrators essentially said that clause in the contract adopts the American rule on attorney's fees. Each side bears its own. It's usually understood that the American rule, which applies in almost all federal litigation, does not prevent an award of sanctions for frivolous conduct. The arbitrators say that's the same rule applicable in arbitration. Now, that may be right or it may be wrong, but it's an interpretation of the contract. What am I missing?
The question is whether or not they could interpret the contract in a violation of Sixth Circuit precedent. For example, a Seventh Circuit precedent. Let's say the Seventh Circuit had spoken to this issue and said, when a contract says specifically...
It's this contract, not what the Seventh Circuit has said about some other contract.
Right, except the Seventh Circuit...
You seem not to acknowledge a distinction between interpreting the contract, period, full stop, and interpreting the contract correctly. One of your problems is we have said that the refusal to see that distinction is itself sanctionable.
But I understand, but no one has argued that this contract is ambiguous. That's never been the issue. This is not a... And this court has determined that specific provisions on remedies aren't for the arbitrators to interpret. Meaning, if you say you can give all the remedies, but you cannot give a remedy of... You can only give direct damages, and it is limited to $50,000. The arbitrators are not allowed to interpret that. This is an unambiguous provision, but there's another item missing here that this court has recognized. There is a separate clause. This is not just a general provision such as in Relastar and the other cases cited by Appellee.
So, counsel, perhaps you can point us to specific language that you said makes your point that the arbitrators exceeded their contractual authority.
So in the arbitration agreement, section O, paragraph 6, there are additional restrictions on an arbitrator's authority. And that is that they may not add, subtract, or modify any of the terms of this agreement. So most of the cases, including Relastar, say, absent something more than just arbitrators may not shift fees, courts have, some district courts under Relastar have said that preserves the inherent authority to sanction for bad faith conduct in the arbitration. So in this case, we have an additional provision over and above the provision, plus a limitation on damages, which I'm not claiming that attorney's fees in this case are compensatory. What I'm saying is the parties went out of their way in multiple provisions to cabin the arbitrator's authority to award additional remedies, including attorney's fees, yet the arbitrators still believe they could interpret the contract to include the authority to add an additional remedy such as attorney's fees despite the clear language of the agreement.
The agreement, though, does allow the arbitrators, or it requires the arbitrators to consider the American Arbitration Association rules, right?
That's correct.
Okay. And as I understand it, looking at Appellee's brief, Rule 49 allows an award of, or allows fee shifting if it's authorized by law. And here the arbitrator said, well, we think ReliaStar gives us that, satisfies that requirement. So it's difficult to see how they exceeded their authority when the contract specifically allows them to look at AAA rules, which they did. And to Judge Easterbrook's point, whether they ended up correctly interpreting Rule 49 or not, that's beyond the scope of our review.
I would have two quick responses to that. One, authorized by law. First of all, ReliaStar is not particularly law. This court's decision to Merrill Lynch, which we cite, say that that the law it's controlled by federal arbitration law, meaning not New York law. So what the courts say on construing arbitration agreements is law in the sense that parties have to follow. But authorized by law, lots of provisions, statutory provisions, provide for contract recovery of attorney's fees. In Texas, where I'm from, we have contractual recovery of attorney's fees. But that would not allow the arbitrators to say, well, the arbitration agreement says expressly, under no circumstances can you ever award attorney's fees, full stop, and then say, but the rule says authorized by law, so we can contradict the agreement that conveys the authority on us to even sit over this case by an internal rule in the arbitration agreement, in the American arbitration rules. Plus, all of the American arbitration rules all have the caveat, both in the remedy section and the attorney's fee section, as have the parties' agreement in there. And of course, all of the case on arbitration says that the first poll star for what arbitration panels can do is the agreement. Then you default within that. So if a panel is there to only provide injunctive relief, it doesn't matter that the rules provide all these other remedies. The parties have only imbued them with the authority to do X. In this case, the parties did not imbue the panel with the authority to shift fees. They went on to say there can't be any subtraction, modification, or addition to this agreement, which is not present in the other cases. And in fact, this court in Polk Brothers said that the absence of that, an additional provision such as an add, subtract, or modify mattered, because it just left the general provision, but it didn't have an additional provision further restricting the arbitrators, meaning like, well, we really mean this. I mean, here's the provisions, but we really mean it, that you can't do anything else. So we believe that the ReliaStar, to the extent that, and even in ReliaStar, the cases it cited of the Synergy Gas case, it talked about sanctions for conduct. Here, if you agreed with ReliaStar for the general proposition that arbitrators, despite the language of an agreement, multiple provisions in an agreement, retained some inherent authority to sanction, that would not have to include attorney's fees. As the dissent in ReliaStar put it, you have the arbitrators, like judges, have many tools in their toolbox to deal with conduct that doesn't require attorney's fees if that's been taken, arrow has been taken out of the quiver by the parties in their agreement. I would also point out that the sanctionable conduct, if you're going to adopt that as the exception to the American rule, that when a party doesn't mention the American rule, but they prohibit fee shifting in their agreement, they are de facto, without mentioning it, adopting exceptions to the American rule.
Why do we have to do any of that in this case? I just don't understand it. Our law is very clear. Arbitration, you accept some risk, right? You agree to arbitration. As long as the decision emanates from the contract, that's it. We're done. There's no role for the federal court to play. That's exactly what happened here.
Then every single case vacating attorney's fees as outside the authority of the arbitrator, because the arbitration agreement or any remedy that is expressly prohibited, every argument retort to that would simply be They drew it from the arbitration rules. So they're completely wrong. It's prohibited by the agreement, but they drew it from a source. They drew it from, or New York law says you can get an injunction, okay, in this case, but the arbitration agreement says you can't. Well, they just missed it. They thought authorized by law meant they could draw it from New York law. There would be no cases vacating specific remedies or vacating attorney's fees if all an arbitrator had to do is say, well, when I interpreted the agreement, I went to the AAA rules. They say authorized by law, and there's some law out there that gives me the authority to give attorney's fees. That's the outline for the panel's jurisdiction. The ability to give an award is in the agreement. They can't go outside an unambiguous agreement, which no one, in fact, I think it's been conceded both below, that there's no ambiguity in this agreement. It's clear. The only question is whether or not it gets enforced according to its terms, or there's an exception either under Seventh Circuit law or general arbitration law for bad faith conduct. But what I was going to say about bad faith conduct was just a simple, this wasn't just a sanction. So if we're going to import the rule on sanctions, then you have to import it in toto. This was a fee shifting of all the fees in the entire case, including the argument that the court should not find bad faith conduct in litigation at the final hearing, meaning they didn't sanction for any specific conduct. They shifted fees for the entire case. And certainly an agreement like this, if you're going to import the American rule, you've got to import the whole thing, the whole bucket of the American rule. And that's the notion of sanctions is not fee shifting for being involved in an entire case for every single filing, every single argument being sanctionable, which no one ever asked for sanctions, by the way. There was never a motion, never a request. In fact, the arbitration panel at length extolled the counsel's work on both sides in this case. So the idea that ReliaStar or the law, even importing the American rule, would allow a complete fee shifting in the face of this agreement with its restrictions just completely flies in the face of all of the cases that say the arbitration panel derives its authority from whatever's written in the document. And with that, Judge Easterbrook, I'd like to reserve the remainder of my time.
Certainly, counsel.
Thank you.
Mr. Whitmer.
Good morning, Your Honors. My name is Stephen Whitmer, and I'm counsel for Appellee American Zurich. The panel has already identified the real question here today, and that is whether the arbitrators had any path to their contractual interpretation. If the answer to that question is yes, then this case is over. Because as this court stated last year in Kinsella, and has stated over and over again, only if there is no possible interpretive route to the award may a non-contractual basis be inferred and the award set aside. Here, as we've already discussed here today, the panel unquestionably had a contractual path to the final award. The syllogism is easy. First, as Judge Lee already explained, the parties agreed to apply the American arbitration rules. Second, those rules state, as already discussed, that the arbitrators are indeed authorized to award fees as provided by law. Third, the parties agreed to the application of New York law. And fourth, New York law expressly gives arbitrators authority to award fees where there's bad faith conduct, like here. And that is the ReliaStar case we've already been discussing. Now, the question is, did the panel rely on ReliaStar? The answer is yes, because the facts of ReliaStar are directly on point here. There, like here, the parties agreed to a contract term saying that each side would bear their own fees, just like the American rule, but then one party acted in bad faith in the arbitration, and the Second Circuit said, well, that fee provision has no application. And the court explained there is an assumption of good faith in an arbitration. And once a party acts in bad faith, all bets are off. So as the Second Circuit explained, these are sophisticated commercial entities, just like our case here. And the parties could have easily executed a contract term, excluding attorney's fees in a situation of bad faith, but they chose not to do so. Now, counsel said that the Sun Holdings was not sanctioned for its conduct. That's just not accurate. As the record will show, there's no question here that the panel found bad faith conduct and indeed entered the attorney fee award as a result. If there's any question about what conduct is at issue, we take a look at the final award because there's pages of facts laying out that bad conduct. For example, Sun Holdings expressly disregarded the panel's pre-hearing security award. As a result, we had to come to federal court, and the federal court upheld the panel's security award, and still Sun Holdings refused to post the collateral until contempt proceedings were commenced before Judge Guzman. In addition, Sun Holdings made conflicting statements to the panel throughout the arbitration, and Sun Holdings never had a valid defense in the arbitration. In fact, Sun Holdings' former risk manager admitted in her testimony that Sun Holdings never even had a dispute with the invoices at issue. And in fact, she admitted that there was no basis for those invoices not to be paid. But nonetheless, she admitted that they didn't pay the invoices because her boss, the CEO, had instructed her, just don't pay the invoices. As a result of that testimony and against that backdrop, she admitted candidly in her testimony that her client, her former employer, Sun Holdings, never acted fairly or honestly with Zurich. It is against that backdrop that this panel entered in its final award, said that all of this activity, all of it is grounded on Sun's conduct in the arbitration. And you read that the panel summarized this bad faith conduct as an ongoing exercise of whack-a-mole. The bad faith efforts just kept popping up incessantly. So, in sum here, the key issue, as this court has already identified, is there was a well-defined path to the final award. Full stop. As a result, the panel's final award directly, by definition, draws its essence from the parties' arbitration agreement. Finally, there's two other arguments that Sun Holdings advanced. They both fail. First, Sun claims that the arbitration was somehow unfair or that the panel was biased. But Sun Holdings never presented those arguments below, and in any event, never presented any facts that would even come close to supporting those accusations. And second, Sun Holdings claims there was some sort of evident miscalculation of figures in the award. Again, that's really nothing more than a disagreement with the panel's fact-finding. There's no facts that would support Sun Holdings' position on that issue either. In closing, the gravity of this case is obvious. A decision not to affirm would create bad precedent. It would allow a party to participate in an arbitration in bad faith with impunity, knowing that it could just hide behind the American rule to avoid paying its opponent's attorney's fees at the end of the day. By definition, that would be a bad result for all future arbitrations in this circuit. So unless this panel has any question for me, I have nothing further.
Thank you, Mr. Whitmer. Anything further, Mr. Henry?
Yes, briefly, Judge Easterbrook. It will be brief since I only have a minute 38 left. So basically, the appellant's argument boils down to, even though Section 606 of the agreement in the record says that the arbitrators shall not limit, expand, or modify the terms of the agreement, nor award damages in excess of compensatory damages under this agreement, if the arbitrators had awarded something above compensatory damages, such as punitive damages, because of the AAA rule that references authorized by law, he would be able to say, well, New York law allows punitive damages here, so that it draws its essence from the law through the rules, even though it's contrary to that provision in the agreement. That's not the way it works. Every case that deals with vacating or modifying remedies, including this circuit's, deal with what does the contract say first, not second. You don't go digging around for areas of law. You say, what power did they have? The other thing regarding the American rule in that synergy case I cited that Star relied on, that is bad faith conduct, not bad faith participation or not coming up with a defense. It's bad faith conduct, and that case said sanctions for the conduct that recoups the fees they incurred because of the conduct. in the arbitration. Every case says in the arbitration. Their position is because a former employer testified we had no basis to not pay the invoices, the entire arbitration is in bad faith, period. So they could shift fees for the entire case. That's not the American rule or any rule on sanctions.
Thank you, counsel.
Thank you, Your Honor.
The case is taken under advisement. Case number 3 for this morning is Jacks against Direct Sat.
Good morning. My name is Teresa Beckvar, and I represent the plaintiffs
Counsel.
in this appeal.
I will call you when the case is ready.
I'm sorry.
Ms. Bavar.
May it please the court. This appeal concerns whether the district court committed reversible error when it decertified a class of satellite technicians after reassignment to a new district court judge. The district court's decision should be reversed for 3 key reasons. First, in decertifying the class, the court granted no deference, or really any consideration at all, to the prior district judge's opinion, certifying liability
So what?
issues under Rule.
So what? You filed a pretrial plan, right? And in response to the pretrial plan, the judge decertified the class. Judge Gottschall may have done that. What difference does it make years later that she gives no deference to Judge Gottschall's decision that was at the very, very beginning of the case?
Right. Well, first of all, the first decision certifying the case was in 2012, and that was at the very beginning of the case. The second decision of Judge Gottschall was in 2015. That decision decertified the case as to damages, following the Espenscheid ruling in this court, and then recertified it as to liability issues under Rule 23C3. Between that decision and Judge Packel's decision decertifying the case in full, nothing changed with regard to the facts, to the regard to the
Let me
law.
put Judge Kirsch's question a different way.
Sure.
Rule 23 says, we have said that class certification decisions are tentative, and they're always subject to re-examination as the case goes along. So what's wrong with re-examining them as the case goes along?
There's absolutely nothing wrong with re-examining the
Exactly.
issues
So you
as
should
the
move
case
on
goes
to
along.
some other argument.
Yes, Your Honor, I just want to make it clear that, Rule 23 opinions are interlocutory orders like anything else. And they are subject to revision, but this court has held in the Williams versus
You can use your
Commissioner
time
case.
as you wish, but I'm trying to help you out.
Yes, thank you, Your Honor. Turning to the second point. The district court erred in finding that none of the certified issues are capable of class-wide resolution. If there's one key takeaway for this court today, it's that there's one issue alone in this case that justifies continued certification of the class. And that issue is whether the plaintiff's time spent commuting to and from their work sites each day is compensable under the Illinois minimum wage law. This issue will resolve an issue that is central to the validity of the plaintiff's unpaid overtimes in one stroke, as the Supreme Court held in Dukes.
So I guess, counsel, I know in the briefs, you and the plaintiffs kind of characterize this as a simple case where there is a company uniform policy that drivers start their clock when they reach the first job, turn off when they leave their last job, and then anything outside of that is would be overtime or compensable, and that wasn't counted. But here, I mean, that might make sense if you have someone working at, at a bank or at a bakery or something, where they actually log in, right? They clock in. But here, my understanding is that DirectSat compensated the drivers through a piece rate system. Is that right?
That's correct, Your Honor.
Where they are compensated by the particular task that they do, and then that total amount is divided by the number of hours worked to come up with an hourly wage that DirectSat then uses to determine whether or not they've met their obligations to pay minimum wage. Is that more or less correct?
More or less.
Okay.
And I know,
I
Judge,
think,
you're familiar with these facts.
yes, it's been a while, but yes. And I wonder whether that doesn't complicate things, even with regard to class issue number 2, that is the time commuting before work, as you call it, and after work, because it's hard to know whether or not an individual, number one, has met the 40 hours or more, and number 2, whether they received enough compensation during that time period to qualify for to be injured as part of their jobs. And so I was wondering if you can address how the piece rate system kind of dovetails with your theories with regard to compensability, or if it doesn't matter.
Well, I can address that, but at first I want to say that the issue with the math, a more simple way to put it, behind what people's damages are, that was taken out of the equation by Judge Gottschall when she decertified the class for damages and the math and recertified it with regard to certain liability issues. But practically speaking, every wage case involves potentially involves weeks where certain class members don't work 40 hours, or they work right on the edge of 40 hours, and if you add 30 minutes to that, it pushes it over. Those calculations can be done on a class-wide basis, and they often are, just based on spreadsheets and records from the defendants of what people were paid, what we know in this case, what exact piece rate every single technician was paid every single week that they worked. And it's just a matter of doing the math to figure out how many weeks were recorded, or how many hours were recorded, how many hours of commuting time for this issue would be added to that each week, and how that would play out damages wise.
What complicates that is Judge Packold's finding that one of the driving forces of how drivers received their tasks, recorded their tasks, and recorded their time was driven really by their individual superiors rather than kind of a company-wide dictates, right?
Right.
And that's a factual finding she found. And I wonder if you could address that.
Yes. So that's my third main point I wanted to address today, was that Judge Packold erred in resolving that factual finding on the merits against plaintiffs. As this court knows.
Okay, I take it though that you concede that. Well, I mean, our law is that a district judge we can review the merits so long as it's necessary to resolve the issue of class certification.
Right. So at class certification, the court's role is to determine whether there are issues capable of proof at trial through evidence that is common to the class. That's the black letter rule here. And the district court discounted plaintiff's record evidence that was common to the class, that DirectSat instituted uniform timekeeping policies and practices that were exclusively established by high-level management.
Well, it's not that she ignored it. It's that she kind of looked at plaintiff's evidence, looked at DirectSat's evidence, and made the preliminary factual finding necessary to decide whether or not continued certification was appropriate. Isn't that what she's permitted to do?
She is permitted to do that, but she is not permitted to weigh plaintiff's evidence that these policies came from the top and supervisors were not permitted to deviate from them and say, well, there's also some other evidence here that says supervisors were permitted to deviate from those policies. That question, whether these uniform policies exist or not, that's a common question common to the class. It's not going to be.
Do you think Walmart against Dukes was wrongly decided?
No, of course
Because in
not,
that
Your
case,
Honor.
the Supreme Court looked at that kind of evidence, which you say a district judge is forbidden to look at.
Right, and this court in.
I'm not asking about this court. I'm
Right.
asking about the Supreme Court's decision.
Right. I want to point to a case where this court dealt
I
with.
am not asking about this court. I'm asking you to discuss Walmart against Dukes. You can't do that by discussing a decision of the Seventh Circuit.
Right. So in Dukes, the court held that cases where low-level managers use their given discretion to make individual decisions without guidance from an overarching company policy do not satisfy commonality because the evidence varies from plaintiff to plaintiff. The Bell Court here, the Seventh Circuit, in that case, they said, in that case.
You're not getting my question. You have said that there's a particular kind of evidence about the way in which a policy is administered that a district judge just can't look at. And I then ask, well, how is that consistent with Walmart against Dukes? Because the Supreme Court looked at precisely that kind of evidence. That's what I'm asking you to discuss.
Right. And in Walmart versus Dukes, there was evidence that each individual supervisor had discretion. Here, and the claims in that case were challenging those decisions. Here, it's the opposite. We are challenging DirectSat's corporate policy that said the workday starts here, ends there. Anything outside of that
What makes it
is
forbidden for the district court to consider this matter? That's the question I'm asking. I understand your argument that having considered this matter, the district judge should have ruled in your favor. But you're making a different argument as well, that the district judge is forbidden to consider this. That's what I'm asking you to discuss. Where does that rule come from? And how is it consistent with Walmart against Dukes?
That rule comes from this court's previous authority. It comes from the Bell case, which has said that evidence of the denial.
I guess think of it this way. Think of the question this way. That in Dukes, the question was one of the predicate questions that the Supreme Court had to decide was whether or not, looking at the evidence presented at the time, the decisions with regard to individual employees was made company-wide or by individual supervisors. The Supreme Court, as Judge Easterbrook noted, did that weighing itself and made that predicate factual finding. Here it seems like Judge Peckle did the same thing. She looked at the question of whether or not the actions of the drivers was caused or motivated by company-wide policy, or whether it was motivated by their individual supervisors. And she made the predicate factual finding that, you know what, it was the latter. That, as Judge Easterbrook says, strikes me very similar to Dukes. And I'm wondering why you think it's different.
It's different because the source of the plaintiff's claims is from an illegal policy. In Dukes, the source of the plaintiff's claims was from the decisions of the supervisors. We're not saying here that the supervisors instructed class members not to record their overtime. We're saying the policy of DirectSat that is in writing and comes from above instructed technicians not to record their overtime outside their regular workday. I'd like to reserve the rest of my time if you
Certainly,
permit.
counsel.
Thank you.
Mr. Doherty.
Your Honor.
Please do not touch the microphone.
I apologize, Your Honor. I thought it might extend. May it please the court, my name is Colin Doherty. I am here on behalf of the defendant appellees in this case. As the questions from the panel have indicated, Judge Packle did exactly what she is required and tasked to do by the longstanding precedent of this court, including the Espen case. That is, on the eve of trial, she had plaintiffs requested and ordered plaintiffs to provide a trial plan. That trial plan was not successful in describing how they could be successful in getting around the inherent variance issues. Similar to, as Your Honor pointed out, she reviewed both Espen, Your Honor's former opinion in the Northern District of Illinois, Judge Shaw's opinion in Meadows, and the Dukes case, and made the predicate findings that that could not happen, and therefore this case should be decertified.
Mr. Doherty, I wonder if you could address one of the issues that kind of percolates in this case, which is the relationship between issue classes under Rule 23C4 and the requirements of 23A and 23B. It seems to me that my impression of reading the transcript of Judge Packhold's order was that she kind of viewed this case as a 23B3 case because she went through all the various factors and decided on predominance as a whole. And as you undoubtedly know, there's a bit of a disagreement amongst circuits with regard to how the 23B3 should be regarded in relationship to 23C4 classes. And in that context, it seems to me that Judge Packhold's decision, whatever you might think of the final result, kind of adopted what I would call what people have called the narrow approach, right, of the Fifth Circuit. And I wondered what your thoughts are on whether her review was, you think, under 23C4 or whether she was applying 23B3.
Well, I think she was applying both, Your Honor, and I think that was her requirement. She had before her a case, unlike many of the 23C4 cases, which are much earlier in the case. They are about resolving a specific issue that then ultimately will apply to the class members in some future separate damages trial, as sort of like Judge Gottschall, who structured her 2015 opinion. She acknowledged that at some point this case, the class members would be sort of decertified and sent to the wind to figure out how to come back and prove at minimum damages, if not liability. So those 23C4 cases are often both earlier in the case. And in this case, one of the issues we think too is plaintiffs also never moved under 23C4. Judge Gottschall did it on her own. But those cases are earlier. They're not as postured as this case was on the eve of trial, where the next procedural step in trial was trial on these issues. And her order on the trial plan specifically addressed how do you try these 14 issues.
By her, do you mean Judge Gottschall or Judge
I'm sorry,
Packhold?
Judge Packhold. Judge Packhold's directive to the plaintiffs to provide a trial plan was a directive that said, provide that trial plan on how you intend to prove these C4 designated issues. They produced that trial plan and failed to do so under 23B3 as well as 23C4 because the proofs under 23B3 are what would prove the C4 issues that Judge Gottschall had allowed to continue after 2015. So in this case, whether you want to call it that she followed the narrow approach or she followed the Espen sheet approach in the sense of this case tracked not only the same defendants, some of the same class members, but the same procedural posture, unlike those C4 cases.
But
it was,
in Espenscheid, that was a 23B3 class, right? 23B3 damages class. It wasn't a 23C4 issues class.
well, yes, it was a 23B3 class, but as Judge Posner indicated in that case, as Your Honor indicated in the Farmer case, and as Judge Shaw indicated in the Meadow case, given, as Your Honor pointed out, the sort of alternative style of pay and pay reality in this case, that there is no average technician, that, pardon me, that liability and damages are inextricably linked, because you have to prove a case, unlike your banking teller example, you have to show that you not only worked some time beyond that was recorded, that work was compensable, that you weren't compensated for it, and that time puts you beyond 40 hours or under minimum wage. That's the part that plaintiffs throughout their briefing sort of skip over, and that's one of the issues Judge Packle pointed out, that the nature of the pay in these cases, makes there is no average technician. There is that damages and liability are inextricably linked. And I would offer that Judge Gottschall did what she was perfectly allowed, despite the fact that we obviously disagreed with it at the time, allowed and empowered to do, in that she allowed, the case was not over, she allowed for 3 more years of discovery post that, before the case was reassigned, and she gave plaintiffs the opportunity, given the unclear nature of a 23C4 case in this circuit, to continue. And then Judge Packle did exactly what she was empowered and allowed and, quite frankly, supposed to do, in our view, on the eve of trial, said, okay, how are you going to do it, plaintiffs? How are you going to satisfy your C4 class now? And they couldn't do it. And she marched through her transcript order, and she explained that they couldn't do it, and did exactly what she is not only empowered to do, but required to under cases like the Dukes case and the Espenscheid case in the circuit. And as our briefing states, we think, particularly under an abuse of discretion standard, that her order should be affirmed and upheld. And if there's no further questions, we would rest on our papers.
Mm-hmm. Thank you, counsel.
Thank you, Your Honor.
Ms. Bavar, anything further?
Judge Lee, your comments hit the nail on the head when pointing out that Espenscheid involved a case that did not involve issues certified under Rule 23C4. I want to address...
does the variance, quote unquote variance, that Judge Posner talked about in Espenscheid, does that also apply to trying to prove the various issues in the C4 class?
No, Your Honor, because each of those issues relate to direct set itself as it relates to its employees as a whole. Whether commuting time is compensable, the issue number 2 I spoke about before, involves every technician commuted. Should that have been compensable? That's an issue that is able to be solved on a class basis for every single person.
And
Whether
yet,
they commuted
summary
an
judgment
hour.
was denied on that issue, right?
Exactly. Summary judgment for plaintiffs was denied on that issue. So, and Judge Gottschall found there were issues of facts that a jury could resolve just on that issue, class-wide.
Thank you, counsel.
Thank you.
The case is taken under advisement, and the court will take a brief recess before calling the next case.
seated and come to order.
We're ready for argument now in the case of Gaynor against Cook Medical. Mr. Cruz.
May it please the court, Michael Cruz for the plaintiff, Jessica Gaynor. Your Honors, it is appellant's position in this case. It's a question regarding the statute of limitations for product liability and in particular medical device cases in the state of Ohio and its application. Appellant contends that the district court misapplied the standard to her case and in particular misapplied Ohio's application of the discovery rule in a medical device case. We believe the district court improperly or misinterpreted a Sixth Circuit opinion, Griffin versus American Medical Systems, to rely on it for the principle that in Ohio, the removal of a medical device necessarily triggers the accrual date for the statute of limitations. What the law says, if we look at the entire body of cases in this context, is that the statute of limitations does not begin to run until a plaintiff is alerted that the device is defective.
Mr. Cruz, I take it then you take no issue with district court relying upon your client's affidavit that you submitted in opposition to the motion. Is that correct?
Correct, Your Honor. As I was saying, the critical date is when the plaintiff is alerted that the device is defective. That's what triggers the running of the statute of limitations. Sometimes that can be when the product is removed and the doctor who removes the product informs the plaintiff at that time that we are removing it because it is defective, but that's not always the case. In Ms. Gaynor's case, her product was removed, as we indicated in the affidavit. It was causing her a physical injury, but she was not informed at that point in time that it was causing her a legal injury as a result of it being defective. She was led to believe by her doctors that this, while doesn't happen often.
Is there any support in the Ohio case law for the difference between physical injury and a legal injury?
Yeah, the body of cases going all the way back to Ostricker, when they first started articulating the discovery rule, draws a distinction between physical injury and legal injury and makes clear that legal injury is the critical point in deciding its discovery rule application under Ohio law.
But I guess my question is a little different. That wouldn't the legal injury be the physical injury? I mean, you know, it's what would be the legal injury if not the physical injury?
Well, the legal injury, the distinction is the physical injury is we may know we were hurt, but the way the cases interpret that distinction is that you know your physical injury was caused necessarily by a defective product or the wrongful conduct of the defendant.
But that would, if that were the case, wouldn't the discovery rule then blow out every other Ohio statute on the statute of limitations in this context?
No, not necessarily, because there are certainly situations, and if you look at the body of cases, the courts go through and they do a fact-specific analysis, which indeed it is a question of fact. There are some situations where, and the courts will say necessarily, there's no other reasonable explanation for what happened other than the product must be necessarily defective based on the injury you suffered. That's not the allegation we have here.
We shouldn't conflate the product defect with the injury, right? They're two separate things. I mean, the discovery rule applies to injury. It doesn't really have anything to do with the latent defect in the product.
Well, and with the way I have read the cases, and I believe the law in Ohio says, is that there is a combination of that. Until the plaintiff is on notice or has reason to believe that their injury was caused by a product defect, indeed, and I think the district court even contends in its order that the plaintiff must be alerted to the defective nature of the product. Now, we believe Judge Young misinterpreted it to the facts of this case, but until the plaintiff has that notice, the clock doesn't start running.
But I guess the way I'm hearing your argument may be different is the plaintiff had notice in, 2013, in March or April of 2013, that there was a defect in the product. And the plaintiff had noticed that there was an injury at the same time. I think your argument is that the plaintiff did not have notice that the product, the defective product, could have caused the injury until the earliest when her mother saw the commercial.
Correct, and I think the distinction is we certainly don't contend that the plaintiff didn't know that she had an injury.
And
that,
didn't know that the product was defective. It's
Well-
just the combination of the two that you have to combine the two to survive the statute of limitations in this case, I think.
Well, and I think what we're saying is the fact that the product, she knew that she had an injury and she knew the product had to be removed. That doesn't mean the product was defective from a legal standpoint. While the product may not have worked, medical products fail on occasion. And I think the defendant would certainly tell you that that's the mere standard for a product liability action is not the failure of a medical device. Sometimes when medical devices go into your body, the natural course of things, your body reacts to it, sometimes they come out. That does not necessarily equate to the product, the defendant being liable for that injury. Something more has to happen. The product has to be defective from a legal standpoint. It is our position at the time, especially based on...
I understand you to be arguing, essentially, that the time to sue doesn't start until the plaintiff has enough evidence to win a jury verdict.
No, that's not what we're saying.
The alternative way of thinking of it is that the time starts with injury, and then you've got 2 years in Ohio to figure out whether you've got a good claim. But it's not 2 years for rest and relaxation, which is essentially how you're characterizing the time limit.
There has to, it is my understanding, and as I believe we articulated in our brief, the law of Ohio, there has to be something to alert the plaintiff that the product is potentially defective. In this situation, her doctor...
Potentially defective and defective are different things. You've been saying so far defective. Potentially defective is just injurious.
And I apologize.
You've got something and it breaks and it's taken out. Well, it broke. It might have been perfectly good and chance might have intervened. But normally one would think of the period of limitations as the time to investigate that.
And I apologize, I misspoke, and it is our position that the plaintiff would have to be alerted that the product is defective.
Right. So until a lawyer says directly or over a TV ad, you should sue about something, the time doesn't start. What's the best Ohio case for that proposition?
There are a number of cases, and if you look at, especially if you look at the case of Grant versus Memory, in which they talk about, there was a cardiac pacemaker that had to be removed and had to be replaced, and they talked about the removal date and whether that triggered the statute of limitations, and the court determined based on what happened that wasn't the case. There was no basis for the plaintiff to know the product was defective based on the course of treatment that the plaintiff received until a later point in time. That they were then put on notice legally that there was a cause of action to start the clock. If there's nothing further, I'll reserve the remainder of my time for rebuttal.
Certainly, counsel. Mr. Hasek.
Thank you, Your Honor. May it please the court, my name is Eldon Hasek, and I represent the Cook defendants in this case. This court should affirm the district court's judgment dismissing plaintiff's claims as time-barred under Ohio law. Ohio has a 2-year statute of limitations, and in this case, plaintiff experienced pain, abdominal pain. Doctors told her that pain was related to her filter, and that the filter had to be removed. And during the removal, or prior to the removal, the device fractured, and it could not be removed in its entirety. There was a fragment that remained in the plaintiff's body. The removal procedure was April 2nd, 2013, and the statute of limitations began to run no later than that point. Plaintiff had 2 years to investigate whether to file a claim, and her filing in May 2016 is over a year too late. The statute of limitations in Ohio for medical device cases was codified in a statute, and what that statute states is that the statute of limitations begins to run upon the date on which, by the exercise of reasonable diligence, the plaintiff knew or should have known that the plaintiff has an injury related to the exposure or the use of the device.
And Mr. Hasek, I guess one question I have is the term exposure to ethical medical device in the statute. Does that just mean just the exposure to the medical device?
That's how we read it. That's the language the statute uses. It does seem a little unusual. I think it makes sense that the statute of limitations is often applied in toxic tort cases or asbestos cases, so exposure is language that would be more familiar in that context. But we read it, and I think the Ohio courts read it as just use of the device or presence of the device, and this is an implanted device that's inside the body. So we read
So
it
it doesn't require exposure to a defective device. It just
No.
says injuries related to the exposure to the medical device of
Right.
whatever kind.
Right, to the use of the device. And so when the Ohio courts talk about being alerted, we read that as, it doesn't say that the doctor has to tell the plaintiff this device is quote unquote defective. I mean, defect is a legal term. It's not a medical term that a doctor might use in ordinary language or in conversation with a patient. So what the courts have said, and I think that the Dunn case from the Sixth Circuit talks about this, it's when the plaintiff is alerted that there might be an issue with the device. And I think we have that in this case. The plaintiff had abdominal pain and was told that the pain was caused by the filter pushing or compressing her bowel, and that was a reason to remove the device. And then during the removal procedure, the entire device could not be removed. So essentially, you have a device that had to be removed, and it could not be removed in its entirety. So it broke or fractured in some manner. And under the standard, that the plaintiff is on notice. The plaintiff is alerted that something unexpected has happened here, and the plaintiff has 2 years to investigate whether to pursue a legal claim or not. And in this case, the plaintiff waited too late. 3 years passed. The claim became time barred in 2015, and for those reasons, the district court's judgment should be affirmed. If there are no further questions, I would yield my time.
Thank you, counsel.
Thank you, Your Honors.
Anything further, counsel?
Thank you, Judge. Your Honors, I will be brief. To address Judge Lee's question about the statutory section when it simply spoke of exposure as opposed to mentioning defective product, if you look at the language of the statute, it talks about the plaintiff being informed of an injury related to a product. If you look at the history of Ohio law, the injury they're speaking about, the statute in that context appears to have been codifying the discovery rule prior to its passage, which I believe was 2006. That statute is codifying the standards that have been applied previously, in which when they speak of injury, they're speaking of legal injuries. So necessarily there must be some relation to wrongful conduct. If you look at some later Ohio cases interpreting that statute in particular, and you'll see in our brief the Hutchins case and the Pettit case, they make clear that that statute doesn't change the requirement that Ohio courts require that plaintiffs have knew or should have known that their injury was caused by the defendant's wrongful conduct, which is not the case here. In light of the evidence that we have presented, we certainly think that this is a jury issue. The jury should be able to decide whether Ms. Gaynor knew or should have known prior to 2016 that she was injured by defendant's wrongful conduct, such that the statute of limitations would begin running. Thank you, Your Honor.
Thank you, counsel. The case is taken under advisement. Lewicki against Emerson is our next case for argument. Mr. Coe.
May it please the court. This court should reverse the district court's grant of conditional writ of habeas corpus because the claim granted is barred from review by procedural default and it was without merit. First, petitioner did not fairly present his federal claim to the Indiana Supreme Court when he petitioned for transfer in his post-conviction case. Because he did not raise the claim through one complete round of state review, the claim is barred from review by procedural default. The claim is also without merit. Appellate counsel was not ineffective for choosing not to raise the speedy trial claim. The claim was not obvious and clearly stronger than the claims raised and would not have been successful. Here, petitioner did not present the operative facts and the controlling legal principles to the Indiana Supreme Court in a way to fairly present his federal claim.
Can I ask you a question about the way, about something about the underlying proceedings, the criminal proceedings? So when you address the prejudice prong of the Speedy Trial Act claim, you talked about the fact that the charging document was amended in July 11th, 2014, but that amendment was based upon facts that was available when the original charging documents were filed. Is that correct?
Correct.
And I wonder, do you have some insight into why it took so long for the state to actually amend it?
Well, I think that as the case got closer to trial, actually getting closer to trial, that then the state cleaned up some charges. One was an alternate way to allege the robbery. So it was a robbery with serious bodily injury, and they amended to add a robbery with deadly weapon. But I would just point out those two.
One of the things that was amended too was the habitual offender.
Correct, and I would just point out that both the habitual offender has been vacated, so the amendment didn't prejudice him at all because he eventually got relief on that. So
it wasn't clear to me from the briefs. I knew that the alternative robbery claim was vacated. It wasn't clear to me that the habitual offender was also.
It was later done in a different proceeding. I mean, that wasn't subject to his post-conviction. It happened before his post-conviction. So.
Okay, thank you.
When you look at the fair presentment factors that this court looks at, none of them are met here. He didn't cite any federal cases.
Can I ask you a question about the prejudice prong? Is the prejudice prong in the Strickland test in addition to the prejudice factor in Barker? In other words, into the Barker factors, doesn't the defendant have to establish that the delay prejudiced him?
Correct.
And under ineffective assistance of counsel under Strickland, doesn't the defendant have to prove that that he was prejudiced by counsel's failure to either bring the argument in the Court of Appeals or trial counsel's failure to stand on the defendant's right to a speedy trial?
I think those two would be looked at a little bit differently. I think that the prejudice
they're different, right?
They are different, and I think that ineffective assistance of trial counsel would be different than ineffective assistance of appellate counsel and how you look at prejudice.
Well, ineffective assistance either prejudice prong, ineffective assistance of appellate counsel. You still have to establish that there's a reasonable probability that they would have won.
Correct.
Right.
Correct.
I mean.
Correct. And here petitioner can't show that because he can't show either that he preserved the speedy trial claim.
Well, even if he did preserve it.
Even if he did preserve it, he can't show prejudice.
It's hard to file motions to continue on the one hand and then stand on your speedy trial rights on the other hand.
Right, and that's why the prong that looks at did he assert it to the trial court just really doesn't go in his favor because he only asserted it very early in the process, and then later in the process he moved for continuances and agreed to continuances. And so, this court's case law just doesn't give any weight to that factor when the defendant is doing both things at the same time, asking for a trial and then agreeing to a continuance.
Puts trial courts in difficult situations when a defendant says, I wanted continuance from June to October, but no further than October.
Right.
Prosecutor's schedule doesn't matter, and Judge, your schedule doesn't matter either, because in October, I stand on my speedy trial rights, even though in June, I agreed to a continuance.
Correct, and, as we allude to in our brief, Mr. Lewicki had a very difficult and complex many criminal matters going at the same time. So he actually was tried for a different case while this was going on, and also had probation violations. So I'm sure counsel was triaging which case to go when, what to do first, and so it was strategic reasons as to why they were waiting on this one as opposed to having this one be one of the first ones. But of course the state believes we don't even get there because he did not fairly present it. There's no case anywhere close that only citing the Sixth Amendment once in a brief, not even connected to your claim or your operative facts, is enough for fair presentment, and so he did not fairly present it here. And so the claim should be denied on procedural default grounds. If there are no further questions, I'll reserve my time. Thank you.
Certainly, counsel. Mr. Tolliver.
Good morning, Your Honors. May it please the Court. My name is Terry Tolliver, and I represent David Lewicki. The issue that we have here is that Mr. Lewicki did present the argument to the Court, and he specifically stated, due to the numerous errors by appellate counsel, the petitioner was denied his rights under the 5th, 6th, and 14th Amendment of the United States, and Article 1, Section 12 and 13 of the Indiana Constitutional.
But did he make an argument based on the Sixth Amendment, or just mention it?
Your Honor, he said that because the speedy trial itself is a constitutional right afforded by the Sixth.
But did he make an argument? Did he make a legal argument? Did
Your
he
Honor,
say, set out the factors of Barker against Wingo and argue their significance?
he could have certainly been a little more articulate in how he did that.
I'm asking whether he did make a legal argument, or just mention it in a drive-by fashion.
I don't know if I would agree that it was a drive-by fashion, but he did mention it.
Well, it's your job not to agree to that.
But he did mention enough to place the state on notice that this was an issue. And we're looking at a fundamental right to a speedy trial, Your Honor.
All right. Let me ask you another question. Do you read the district judge's opinion as finding that the Sixth Amendment was, in fact, violated?
I read the district court judge's opinion to be that it's a close call and that
It's a close call, but not that it was violated. Without a finding that the constitutional right was violated, how is it prejudicial to omit the particular issue? I mean, let me give you in general terms, and I know you won't accept these, again, because it's your job not to accept them. Suppose a defense lawyer arguing in the Indiana courts has 4 potential issues, evaluates all 4 of them as losers, and makes 3 and loses. Is that ineffective assistance because he left out the 4th loser?
that could be based on trial strategy, Your Honor.
No, I'm asking whether it can be ineffective assistance to present fewer than all of your losing arguments.
No.
Of course not. Well, then that's what struck me when I read this case. I have never before seen a case where a district judge found ineffective assistance of counsel for omitting argument X without finding that argument X was a winning argument. And there was no such finding in this case. Are you acquainted with any precedent for that?
I am not, Your Honor. The way I read the district court's decision was that she left that to the state courts.
She didn't decide it. And that's the problem. Without having decided it and said that had this argument been presented, it would have won, I don't see how it's possible to say there was prejudice from omitting it.
Your Honor, I think the district court judge presumed prejudice based on it being a fundamental right. And
But then you have to answer my first question by saying, if you got 4 losing arguments, all invoking the name of the Constitution, the lawyer must present all of them because they all involve fundamental rights. But that can't be right.
well, I think what we're looking at here is that by giving the state nearly 3 years to try him, that we can presume that that resulted in prejudice to him because, as we noted in the brief, that allowed the state to have time.
Let me put it differently. One more variation. Is there any way the Sixth Amendment could be a winning argument for the defendant, but the equivalent speedy trial claim under Indiana law be a losing argument for the defendant? In what way is the Sixth Amendment argument more favorable to the defendant than the Indiana version?
Well, I think that when we're looking at it, they're one and the. I think we would look at them as one and the same.
Yeah, but the problem is counsel presented a state law speedy trial argument and lost. And so if it's one and the same with the Sixth Amendment, then the Sixth Amendment is just a losing argument. I hope you can see my problem.
Well, I think the concern with that, Your Honor, is that when we're looking at it, I don't think we should be requiring defendants, especially in Mr. Lewicki's case where he was acting pro se, to have to use the correct words in order to proceed. The Sixth Amendment right to a speedy trial is fundamental. The courts are aware that when somebody is asking for a speedy trial, that is the right they're invoking. To say otherwise would be a difficult lead.
No, but you've just agreed with me that there's no way to win under the Sixth Amendment if you lose on a state law speedy trial claim. And the state law speedy trial claim was presented.
I understand, Your Honor. But I think when we look at that, again, so we've got whether he fairly presented it to the state Supreme Court, we believe that he did. And again, when you're looking at the arguments that were presented, we looked here, the appellate arguments were an argument about an evidentiary arguments. There was an argument about jury instructions, and we would think that like the district court did, that the Sixth Amendment claim is the more important one. And when faced with, are we going to argue about a jury instruction argument or a constitutional violation, it would seem that the constitutional violation would be the appropriate argument to present.
Mr. Tolliver, isn't there, though, evidence in the record, the post-conviction record, that appellate counsel evaluated this issue and considered this amongst the other objections that he was going to assert on appeal, and for whatever reason decided not to assert it?
I don't know if that was fully developed at that stage, because I don't recall where, I don't believe there was an evidentiary hearing on that to determine why the attorney chose not to pursue it.
I guess I'm just looking at, and perhaps was the appellate counsel Mr. Byer?
Yes.
Okay, and on page 29 of this transcript, which I think is a direct examination conducted by the petitioner, says, Mr. Byer, when you reviewed my record of appeal, did you see the multiple letters I wrote to the court pertaining to the speedy trial issues catch your attention? And Mr. Byer says, yes, because those were in the clerk's portion of the record. Question, did you investigate this issue? Answer, yes. So, as you know, it's very difficult to proceed under Strickland with an argument that an attorney didn't present a claim when the attorney considered the claim. And for whatever reason, presumably strategic, because that's what we presume, he didn't present it. And I wonder what your response to that is.
Well, I think my initial response would have been there probably should have been some follow-up questions at that hearing to try and elaborate why that wasn't done. But when we're looking at a situation like that, I think the bigger concern that we have is that when you're looking at why attorneys present certain issues and not others, is how he was harmed by it. And this seems to be one of those issues where Mr. Lewicki basically tried to do what he could. So on one hand, he made it known that this is something I want done. I want a speedy trial. It needs to be pursued. Nobody's listening to me, so I'm going to send letters to the court. Nobody's listening to me. Please give me a speedy trial. Now, the state's position is accurate. Well, the courts don't read those letters because you're represented by counsel. But what is Mr. Lewicki supposed to do in a situation like this, where he's letting he's making it known that he wants a speedy trial. His counsel is refusing to present that to the court on his behalf.
But then how do you respond to Judge Kirsch's concern that, during the proceedings, Mr. Lewicki also, through counsel, agreed to some of these continuances?
Well, if you look at the way those letters are written to the court, you can almost see how the desperation just goes on. So we go from, hey, just wanted to let you know that I asked for this, and I was told I'd be contacted in a week. Nobody's contacted me. And then it gets, I really want this speedy trial. I've asked for it. I've been sitting here for a year. So I think how you respond to that is that what more is he expected to do? Either he's made it known that I want a speedy trial and it was ignored, or he didn't do a good enough job in presenting the issue, in which case he was denied the effective assistance of counsel.
So are you saying that his attorney agreed to continuances without Mr. Lewicki's authorization?
I don't know that, but we could also read into that at some point you just give up and decide that this is what it is. We do know that he's asked for this speedy trial at the beginning, and that he makes it known that I want to be tried, and then it gets to the point where he decides that whatever you want to do, do it. And I see that my time's expired, so if there's no further questions, thank you.
Thank you,
Your Honor.
Mr. Tolliver. Anything further, Mr. Coe?
Just a couple record things. If you look at the next page of the transcript with appellate counsel said he didn't raise a speedy trial claim because he thought it was waived, because it wasn't preserved below. And that is a good reason for not raising a claim as appellate counsel, is that no one objected below, and that's why appellate counsel didn't raise the issue. And on the letters to the court, I would just again point out that the petitioner sent those early on, which we often see with criminal defendants when they first get arrested. They want to move things along very quickly, and then they talk to their attorney and realize that that's not in their best interest, and so agree to continuances, and that's what happened here. We ask that you reverse the district court. Thank you.
Thank you, counsel. Mr. Tolliver, we appreciate your willingness to accept the appointment in this case and your assistance to the court as well as your client. The case is taken under advisement. Our final case of the day today is Bolin against the Judah Christian School. Ms. Hager.
May it please the court. Bethany Hager today on behalf of the plaintiff appellants, Ms. Bolin, Ms. Humphreys, and Ms. Potest. And we're asking that the court reverse and remand this matter for further trial proceedings, and that the district court, we believe, incorrectly dismissed the plaintiff's claim before the trial setting. We believe that in the district court's opinion, the judge did not accurately and appropriately take plaintiff's allegations as true and all reasonable inferences in their behalf that was supposed to be given them, and incorrectly found a reasonable accommodation that in fact did not exist in the sense of testing being offered to the plaintiffs in the place of the COVID-19 vaccine. When the plaintiffs expressed their religious objection to the COVID-19 vaccine mandate that was being asked of them as a condition of their continued employment, the burden then was on the employer to take that objection seriously and to accommodate it in ways that did not impose another burden on the plaintiffs the same or similar as what they had already objected to. And in fact, they did raise objections to the testing as well.
Where in their complaint do they say that they have a religious objection to medical testing?
To the testing?
Yeah.
That is in paragraphs 16 through 21.
Does it talk anything about a religious objection, or does it talk about they just don't like it, they have a moral?
It is a moral objection to the testing.
Is that a religious objection?
It is. Matters of conscience are a religious objection. In the Title VII context, different deference is supposed to be given to the employee who is raising their religious, their conscientious, their moral objection to the process that's being asked of them.
Ms. Hager, when your clients went to the employer in the first instance, did they give them any more detail as to what those religious convictions were, or did they just say, it's against my religious beliefs?
So there are 3 different schools involved, 3 different teachers, so 3 different sets of conversations. And they did raise their specific objections to their respective employers, and then conversations followed.
So they did provide
written submissions.
So they did provide some more information other than just it violates my religious beliefs.
Yes.
And so, but the complaint doesn't do that.
The complaint details that, for instance, they objected because of the link to abortion in the development of the vaccine, even in the development of the testing procedures. There was objections because
Well,
of
I'm wondering, like, for example, did one would expect someone that would approach an employer to say, my religious background is X, and according to that background, because of that background, I am objecting to such and such. Was that sort of information provided to the employer?
It's my understanding they did include that in the conversations.
And yet that's not included in the complaint.
Because it's plaintiff's position at the time of filing these complaints and bringing them to the courts for attention that in the context of that COVID-19 vaccine discussion, it is enough, with all the murkiness that surrounded the vaccine and testing, it is enough that plaintiffs' employees raised the objection and said, this process, that you're asking me to submit to violates my conscience. I cannot in good conscience comply with what you're asking me to do in order to keep my job. And when they raised that objection, especially with regard to the vaccine, then they were told, well, then you have to submit to testing, which is akin to being told, well, we'll respect your religious beliefs, your conscious objection, but we're going to slap this badge on you so everybody knows. And that is not what Title VII and the case law surrounding Title VII requires of the employer to do. The other issues are addressed in the pleadings and the briefs. If there's no other questions at this time, I understand there's many on the other side to speak, so I will reserve time for rebuttal.
Certainly, counsel. Mr. Slade.
Good morning, Your Honors. May it please the court. My name is Randall Slade. I represent Judah Christian School in this matter. In September 2021, during the ongoing COVID-19 crisis, Governor Pritzker issued Executive Order 2021-22. At issue in this litigation is Section 3 of that order, titled Vaccination and Testing Requirements for School Personnel. Subsection C states, schools shall exclude school personnel who are not fully vaccinated against COVID-19 from the premises unless they comply with the testing requirements specified in subsection D. Subsection D essentially provides that unvaccinated employees would not be excluded if they tested weekly for COVID-19. No other alternatives or accommodations were provided by the executive order. Under the executive order, school personnel must vaccinate or test weekly, or they cannot be on school grounds.
Was there, I'm just curious, if someone came to you and said, I have these genuinely held religious beliefs, and you agreed that they were genuine and genuinely held, and they said, I can't submit to the vaccine and I can't submit to testing, what other alternatives do they have?
I am not aware of an alternative because it would require the school to essentially say, we're not going to comply with state law. The school's in a position, and this isn't with respect to the undue hardship argument, which I don't think the court needs to get to, but that places an undue hardship on the school of having to say, we're not going to follow the law and potentially expose ourselves to action from the state, licensing issues, all sorts of Pandora's box of potential consequences for a school for refusing to comply with what they understood, and my client certainly understood to be a valid executive order that they had to follow.
So the only choice that person would have would be to challenge the executive order itself?
If in setting aside, the testing is the reasonable accommodation for vaccination, if there is sincere religious objection to testing, I don't think there is another alternative for our clients. They can either violate the executive order and allow the individual to stay on school grounds, or they have to exclude them pursuant to the executive order. I've read the executive order many times, and I don't think there's any wiggle room on that issue. So the defendants are thus placed in a position they're required by the executive order to exclude unvaccinated personnel that did not agree to test weekly for COVID-19. The plaintiffs in this case sought an exemption for vaccination due to sincerely held religious beliefs, and the defendants agreed to accommodate those. the executive order does not mandate vaccination. It does allow for testing for those with religious objections to vaccination or any other objection to vaccination. There may be medical objections or any other objection you can think of why someone would not be vaccinated. The plaintiffs refused the test and were excluded, as the defendants in this case were required to do. While Title VII does require employers to reasonably accommodate religious beliefs, in this case that's what the defendants did, which is what Judge Lawless found as well. The accommodation of testing is certainly a reasonable accommodation for someone that does not want to vaccinate. Plaintiffs would not have to vaccinate and violate their religious beliefs. An accommodation need not to be preferred or most beneficial to the employee under the case law. This removed the conflict between the plaintiff and the religious objection to vaccination. I do know my colleagues want to speak as well, so I will cede my time.
Thank you, Mr. Slade.
Thank you.
Ms. Nicholas.
Thank you. May it please the court. My name is Susan Nicholas. I'm here on behalf of Staunton Community School District number 6. And I would like, if possible, to address the issue with the failure to actually state a cause of action under Title VII. And this is due to the failure to assert a religious belief that's entitled to protection under the law. While there is broad definition for what constitutes a religious belief, in general, it must both fit into a person's own scheme of things and occupy a place parallel to that filled by God in a traditional religious person. And we contend, and contended in the lower court, that there was no such allegation in this complaint. While there was an allegation about a religious objection to the vaccination, at no point did any of the defendants make an effort to force the plaintiffs to get vaccinated. Instead, under the executive order, the requirement was if you do not vaccinate, then you must test on a weekly basis. And in looking at the complaint, there is no allegation of a religious objection to the testing requirements. There are allegations of moral consciousness, sincere beliefs that they don't want to submit to health care as competent adults. They should be able to do what they believe is medically necessary, and that they disagree with some of the reactions of asymptomatic testing, such as health complications of nosebleed, allergic reactions, and things of that nature. However, none of those things actually come up to the bar that is required by Title VII pleadings to entitle the plaintiffs to protection. And because of that, there's been an entire failure to state a cause of action, setting aside the accommodation that was effectively built into the executive order. And it's been held that social, political, and economic philosophical beliefs and personal perspectives and preferences are not the same as religious beliefs. What I would contend is that that is exactly what was alleged in plaintiff's complaint, and that's why they failed to assert a cause of action. In addition, even if the court were to find that there was sufficient language in the complaint to allege a religious belief, there's also the issue of undue hardship. And in this case, the accommodation requested would require a violation of the law, which in itself is an undue hardship.
Thank you, counsel.
Thank you.
Ms. Satterley.
Thank you, Your Honors, and may it please the court. My name is Fraser Satterley, and my firm represents North Mac Community Unit School District number 34. I want to take a brief moment to address the claim that was made by Ms. Hager regarding the district's essentially slapping what is equated to a scarlet letter on those folks who don't want to be vaccinated. And I think this is an important point. Anyone who did not want to vaccinate for any reason is subject to the same requirements. So that could be medical reasons. Someone has an allergy to the vaccine. It could be political. It could be religious, or they just plain forgot or didn't have time to go get the vaccine. All of the people who chose to remain unvaccinated for whatever reason had the ability to do so, and this applied blanketly to all of them. It was not tied to any religious beliefs asserted by plaintiffs, so they haven't asserted a religious tenet that's been violated here, nor does their complaint actually tie it to religion and that they were discriminated against specifically on their religion. The other discrete issue that I want to bring up with respect to my client is the 90-day limitation period set forth under Title IX. We believe that all the plaintiffs have an uphill battle here. I believe that's especially true for plaintiff Amanda Humphreys, who is North Mac's former employee. Her claim is time barred where she failed to file a complaint within the 90-day period following receipt of the notice of her right to sue letter. The district has consistently pled, both in the lower court and here on appeal, that plaintiff Humphreys is time barred, and in each instance, the district's claims in that regard have been met with silence, and it's our position that that silence is deafening. They've made one conclusory allegation in their complaint, saying that all plaintiffs have timely filed their claims with the EEOC and have either received within the past 90 days or expect to receive their right to sue letters. There's no indication in the complaint as to which plaintiff received notice or when, but in plaintiff Humphreys' case specifically, we know that the EEOC letter was issued on August 15th, 2022 because we received the notification via the respondents portal as well. The initial complaint was not filed until November 15th of 2022, and that's 92 days after receipt of the notice to right to sue. Now, the 90-day time frame, it's not a recommendation, it's not a guidepost, it is strictly applied. So even if a complaint is filed on the 91st day, it is time barred under this requirement for Title VII. The district court noted this in its opinion that was issued on September 28th of 2023. And despite the fact that the lower court found that it was time barred with respect to Plaintiff Humphreys again did not address that argument here on appeal. So it's our contention that with respect to North Mac, her claim is time barred. But in any event, on the merits, the district court properly concluded that they failed to state a prima facie claim. Thank you.
Thank you, Ms. Satterley. Anything further, Ms. Hager?
With brief regard to the allegations about the 90-day time limit, again, on the face of the complaint, which must be taken as true, plaintiffs
It's
allege
too late to
that
argue
they...
this.
All right. Thank you, Your Honor.
You ignored it in your opening brief. You didn't file a reply brief. That issue has been forfeited.
Thank you, Your Honor. With regard to the executive order and its force as law, supposedly, we did address this. Youngstown, which is a United States Supreme Court case from 1952, says executive orders cannot change existing law, and that remains the state of the law today, and it applies to Governor Pritzker's executive order as well. And the fact is that Illinois has a public health scheme to address the need for vaccines and for medical testing when those are required. That's in the Public Health Code. In fact, Illinois even has a more specific statutory scheme.
What accommodation did your clients request?
They would have continued to comply with taking measures in response to symptoms, to staying home when sick.
Be concrete. What accommodation did they request?
They requested not having to submit to the vaccine, which...
That's not an accommodation. Did they, for example, offer to wear high-density respirators?
For the time period prior to the eviction order, they had complied, or the executive order, they had complied with the school's requirements to wear a mask, to stay home with symptoms. They would have continued to comply with those mitigation measures.
Is this something that was argued to the school districts, to the schools?
It was part of the conversations. I don't recall if it was something that's come up in the course of the litigation.
Okay, thank you.
Thank you. And again, the United States Supreme Court has said that these vaccine and response to disease mitigation are a public health issue, not a workplace safety issue. It wasn't the place of any of these school districts to step into that. It wasn't the place of the executive order to step into that. It had already been addressed. Illinois law addressed it, Title VII addressed it, and plaintiffs should be allowed to proceed with their claims. Thank you.
Thank you very much. The case is taken under advisement, and the court will be in recess.